Alrighty, good morning, everyone. My name is Jonathan Su. I'm the moderator for today. You are here for personal injury, rights of migrants to file a claim, litigation, and trial procedure. Thanks to you for joining us for the live MCLE session, and hello to you if you're watching the YouTube recording. This is coming to you from the international section of the BHBA, but we are happy to be co-sponsored today by the immigration section and the personal injuries section. So thank you to them. About an hour ago, you should have received an email with the materials for today's program. That'll be the slides that you'll be seeing later today. And later on afterwards, you should be automatically receiving your MCLE certificate. So be on lookout in your inbox for that. Otherwise, please feel free to contact us if you have any problems. If you want to start the PowerPoint, we can get right into it. We have a jam-packed session for you. We can move to the next slide. I will start with the bios. So here are your all-star team today. We have Patricia Alabise. She is a personal injury attorney at the Dominguez firm, and she represents people who have suffered injuries by negligent third parties in all types of accidents. So welcome, Patricia.
Thank you.
We also have Pablo Mezquita. He's a litigation paralegal at the Dominguez firm. And he works in Patricia's litigation team and is specialized in negligent third-party automobile and premises liability cases. Hello, Pablo.
Thank you for having me. Hello, John.
We also have Eustace de Phalle, is a principal at Rains, Lucia, Stern, St. Phalle, and Silver PC. Eustace has established himself as one of the California's top personal injury trial lawyers. Currently, he manages 3 offices in California and has been managing a trial team for over 15 years. Throughout the course of his career, he has handled almost every type of tort case in California. Hi, Eustace.
Hello.
And lastly, but not least, we have Caroline Feldstein. She is an associate at Rains, Lucia, Stern. She represents people who have suffered serious injury as a result of automobile accidents, defective products, dangerous premises, negligence, and international torts. Welcome, Caroline.
Thank you for having me.
Awesome. So Eustace, how about you get us started? What we're going to do today is roughly go through the life cycle, if you will, of the personal injury trial. We would happily take questions, but please leave them either in the Q&A at the bottom of this Zoom feature here, and we will try to get to them at the end, towards the end of the session. So Eustace, thank you.
Thank you. So I know we're going to have a very wide range of people in our audience, so I'm going to try to touch on certain things in somewhat of a simplistic version, and then as well go through more of the legalese jargon that one might use. So we'll try to be able to cover all sort of spectrums here. We're basically starting off with the idea of if you have a claim in California and you intend to bring a claim for injuries, then what are some of the foundational things that someone needs to know about and be thinking about as they're going to be bringing such a claim, either representing someone who's an immigrant or if in fact you are the person bringing the claim. So generally in California, personal injury claims are going to be a legal action where someone's been injured and they're seeking remedies for the harms that were caused by somebody else or another entity. These can be everything from a simple auto case, a slip and fall, a medical malpractice case, an industrial injury, a work injury, product liability. There's all different types, but they all generally follow a very simple principle, and it's usually underneath or some portion of the aspect of negligence. And so negligence is a term that we use all the time in our everyday language, but it does have a very specific definition and in the law, and there are very specific elements to the cause of action. So generally speaking, under a negligence claim, you get to bring a claim if someone has harmed you where they have failed to act as a reasonable person would under the same or similar circumstances. So we use not what that specific person's knowledge is or the failure to have knowledge. You're actually looking at what a reasonable person would do under the same or similar circumstances. And if they're in a position where they have some form of authority or special relationship, they may have a heightened duty than what the knowledge would be of the average person. For instance, if it's a construction site and someone's doing construction work, The reasonable person standard would be what applied to that type of person under those set of circumstances. Generally speaking, in California, this is the foundation for this is statutorily in CCP 1714, where everyone is responsible not only for the result of his or her willful acts, but also for any injury occasioned to another by their want of ordinary care, skill, management of his or her property or person. Now, I'm going to come back to that in a second, but why don't we go to the first slide? So in the law for negligence, we generally consider that there are 4 elements to the cause of action of negligence, and that is duty, breach, causation, and damages. And that is shorthand for the concept that everybody owes everybody else a duty to act as a reasonable person, as I just articulated from the statute. Now, one of the ways that we look at this is that society will often establish certain rules that may be what the duty is under particular circumstances. And the easy analogy for everybody to understand what I'm talking about is the vehicle code. So we all know that a reasonable person driving down the street is required and has a duty to stop at a stop sign. If they fail to stop at the stop sign and they drive through the stop sign, then they have breached their duty. If they hit a pedestrian in the crosswalk, then they will have injured the person, and by breaching the duty, they will have caused the damages to the person. Now, damages can be both physical injuries to a person, but it can also be emotional damages, and then it can be all of the various things that flow from those injuries. That can be medical bills, both past and future. It can be lost wages in the past, as well as loss of wages or earning capacity in the future. And then in addition to that, generally the law will allow for something called household services. And this is what generally one does around the home that is, in essence, an economic benefit to the person. Now, the whole idea here is that we don't do an eye for an eye, and we come up with monetary damages in order to assess the harm that happens to somebody. And when we're attempting to assess this, we're going to be looking at basically what can be proven through admissible evidence. I like to often say to my clients when they come in the door, it's not necessarily about the truth, it's about what we can prove. And so it's really, really important to always try to think about that the standards or the principles that you're going to be applying in any kind of case. Generally, it's going to be something founded on negligence if it's a personal injury claim, and you're going to have to be proving it through admissible evidence. So that's either going to be documents, physical items, testimony, or opinion testimony. So those are the things that you kind of need to keep track of. Why don't we go to the next slide? So I had already touched on this a little bit. Code of Civil Procedure 1714 establishes that everybody must act as a reasonable person would in the same or similar circumstances, either as to their person or their property. So when we refer to property, that could be the use of a vehicle, or it could be real property, for instance, premises where you manage a business or your own home. The idea here is that all of these general concepts of what we would talk about as negligence applies to these various different types or theories of negligent claims that can be brought. So we've got general negligence, we've got premises liability, that's the failure to use reasonable care in the management of your property, or it could be when you're driving a vehicle, or it could be when you loan somebody a tool. Let's say it's a saw for them to do some work on their home. You must use reasonable care and act as a reasonable person would under those circumstances. Generally in negligence cases, it's important to always understand that while the law gives you the right and the ability to assert your rights in order to get compensation, it also says that you have a time period within which you must do it. And these are referred to as statutes of limitations. So all different types of claims have statutes of limitations. Generally for negligence and most claims, it's going to be 2 years However, there are many situations where it's shorter. If it's a medical malpractice case, you have to do what's called a 90-day letter before a 1-year statute runs. If it is a governmental entity, then there may be a shorter time period, like 6 months, where you must bring an initial claim to the governmental agency. But these are all specific nuances that would have to be researched in any given claim. So most people who are going to either be here as immigrants or as people who are here traveling for vacation or what have you, if they are injured, it's going to be most likely a negligence claim. And that negligence claim could be in the form of a medical malpractice claim, an auto claim, a general negligence claim. It could be premises liability, product liability. All of these types of claims are founded in the concept of negligence. And it is often a very easy tool and way to describe what the situation is and help analyze the situation for a client when they come in. The other thing that I think I want to just touch on briefly before Caroline jumps in here is that in California, you have several different types of court systems that you could end up being involved in. So the first one is just the general civil court system. And that would cover all the different types of civil claims that we're generally talking about here. But if someone gets injured at work, the immigrant may also have what's called a workers' compensation claim. And that is a dual system, legal system that tracks like the civil claim. They can both be happening simultaneously. And each system has a set of rules as to how the two will overlap and ensure that there is not any overcompensation or undercompensation of the injured person. So it's really important to remember that if somebody gets injured at work, even if they are not a citizen of the United States, they still have a right to workers' compensation insurance and the workers' compensation system, regardless of whether they're a citizen of the United States. Then, in addition to that, we have civil cases both in state court and federal court, and we're going to talk a little bit later about the distinctions and some of the things you need to be thinking about. At this point, I think I'm going to hand it over to Caroline, and I'll let her go over some of the unique issues that always need to be considered when you're dealing with someone who's a non-citizen of the United States.
Thank you, Eustace. Can I please have the next slide? Thank you. So now that we have established how and when a plaintiff can file a personal injury action, we'll discuss the rights of undocumented immigrants to bring a personal injury claim. In 2016, according to the Pew Research Center, there are roughly 2.2 million undocumented immigrants living in California. It's estimated 14 to 20% of California's total immigrant population. The undocumented population in Los Angeles, for example, is estimated at over 9%. I'm part of California immigrant population. I'm originally from Brazil, so throughout this presentation, you might notice the accent. I want to focus on this fear of deportation or being reported to ICE is the primary reason why some undocumented immigrants do not report an incident or they don't try to collect the financial compensation they are entitled to under the law. Can I have the next slide, please? This fear of being on the radar of ICE is due to the old case law. In 1986, in Rodriguez versus Klein, the plaintiff, an undocumented citizen from Mexico, suffered injuries in California and sought compensation for future earnings and medical expenses. The compensation was awarded according to the wages and the healthcare expenses relative to the plaintiff's home country. This resulted in a much lower compensation that the plaintiff would have received in the United States. The issue in this case is that it precluded the plaintiff from bringing a full value claim just based on the fact that he was an undocumented immigrant at the time of the incident. Since then, California lawmakers have made some attempt to embrace its immigrant population. The change came in 2016 with Assembly Bill 2159, which was incorporated into California Evidence Code 351.2. which states that in a civil action for personal injury, evidence of a person's immigration status shall not be admitted into evidence and it's not discoverable. This new law has important consequences for ensuring equal access to justice to those who were harmed. Can I have the next slide, please? This law states that opposing counsel isn't allowed to try to find out the plaintiff's immigration status. So a plaintiff's legal immigration status is not admissible in court. It cannot be used against the plaintiff, and it cannot be entered into the trial record. With this new law, the truth is a plaintiff's immigration status does not affect their right to bring a personal injury case. In other words, California protects all individuals that were harmed in a personal injury incident. So an undocumented immigrant can bring a personal injury claim just like a U.S. citizen. And ICE cannot deport an undocumented immigrant just because they file a personal injury claim. Regarding non-U.S. citizens' personal action based on work injuries, California has also embraced undocumented immigrant workers that suffer injuries. That's through California Labor Code Section 117.5. which states that all protections, rights, and remedies are available under the law to all individuals regardless of their immigration status. In addition, any person employed in the state can claim benefits available under state law, including workers' compensation benefits. Additionally, California Labor Code 244B prohibits employers from using threats related to immigration status to retaliate against employees who have exercised their labor rights. This is an important law that stops employers from taking advantage of undocumented workers. In conclusion on the section, immigration status is irrelevant to the issue of fault regarding a work injury, and no inquiry can be made as to the immigration status unless it's to comply with federal law. Pablo, Patricia, I would like to pass here for you guys to start on your section.
Thank you, Caroline. Can I get the next slide, please? So at our firm, at the Dominguez firm, we handle both pre-litigation and litigation matters. So I wanted to touch a little bit on what the life of a personal injury case looks like. So your typical auto accident, slip and fall, trip and fall, for those that may not be so familiar with all that goes into a personal injury case before it hits litigation, it goes to court. So typically an incident will occur, the potential client is injured, they may or may not seek treatment before they seek attorney assistance, and then they come to your office. So what do you do when someone comes to your office? It's very important to sit down with the clients, and if there is an issue of immigration status, making them very comfortable and them understanding. Sorry about that. I apologize, you guys, my cell phone rang. Let me get back those slides up here. So it's very important that you make the client comfortable and understanding that there is no issue with their immigration status. They don't need to worry about that coming up or it preventing them from being able to seek any sort of recovery for the negligence of someone else. Another thing, when you meet with your client, you want to make sure that you're aware if there's any potential issues that could come up with a loss of earnings claim or things of that nature. Unfortunately, a lot of immigrants in the United States may have used someone else's social security number or used a different ID number to look for work. And that's something that we need to be aware of when you get brought onto a case, so that you know how to approach that when it comes to a loss of earnings claim. Once your client has completed treatment, you will still be usually in the pre-litigation phase for those injuries that are less in nature. So I'm not talking about your catastrophic injuries where you have an amputation or a significant traumatic brain injury, but something more of a neck, back, orthopedic type injury where you may not necessarily want to file a lawsuit very early on. You may want your client to finish treatment and try to get that solved within the pre-litigation arena. Now, if you can't resolve in the pre-litigation arena, you need to make an assessment as to whether you want to move forward with filing a lawsuit on that case. Can I get the next slide, please? So let's say you have tried to resolve this case in the pre-litigation arena and you haven't been able to. One of the reasons you may file a lawsuit at that point is because you've reached an impasse in settlement negotiations. There's many factors you want to consider. You want to consider if the value of the claim, if it's worth it. You want to make sure that you're going to put your client in the best position possible with the best result that they can get. So it's, in my eyes, a risk-benefit analysis, right? What can we gain from filing a lawsuit? And if it's worth the client's while to go down that rabbit hole that can, last a year and a half, 2 years, or so on. You also want to think about what type of case you have in the personal injury arena. Is this your typical auto accident case or slip and fall with a private defendant, or do you have a government agency on the other end of this accident, and determining whether the value is there to proceed against the government entity and making sure you comply with, as Eustace said, special provisions that we need to comply with when there's a government entity involved. I like to think of it as the rule of 6. If you've identified that there's a government agency on the other end, you have 6 months from the date of incident to file your administrative claim, and then they have 45 days to either accept or reject your claim. If they do reject it within those 45 days, you would have to file your lawsuit within 6 months of that rejection. If they do not reject it, I believe it's 2 years from the date of incident. However, as a practice point, I would just always calendar 6 months from whenever you submitted that administrative claim to make sure that you don't miss that important deadline. Now, when it comes to minors' compromises and choosing a guardian ad litem, a guardian ad litem is important to consider when you have a minor client whose parent is an immigrant or not a US citizen. That is an important factor to determine who's going to be before the court to represent that child's interests. At some point, you'll eventually get a settlement or a judgment, and you may have to open a court order blocked account that would require the guardian to sign some paperwork. So the importance of that is understanding whether the client or the guardian of that minor has the ability to open bank accounts, has the proper documentation and things of that sort. All of that goes back to your initial client meeting. You want to make sure that your client feels comfortable enough with you to be honest with you about these important uncomfortable conversations that you may have to make sure that you're protecting your client's interests. You also want to make sure that when you're preparing your complaint and you're drafting your complaint, you're careful and cautious as to what you include in that complaint. Now, whether it's a judicial counsel form or you prepare a long form complaint on a pleading paper, you want to make sure that you don't include anything that could become public record that could affect your client down the line. No private information that, if unfortunately there is an immigration case, can come up and somehow harm their immigration process. So just be mindful of what you include in these complaints. Pablo, I'm going to pass this on to you, the service on the defendant.
Okay, thank you, Patricia. So once a complaint and a summons have been filed, the next step is to serve the complaint and the summons and the court documents on the defendant. So what is the timeline to serve? So California Code of Civil Procedure article or section 583 establishes a deadline of 60 days. So 60 days since the filing of the summons and the complaint to serve it on the defendant, and then to report service to the court by filing a proof of service of summons. The next question is, how strict are the courts enforcing this 60-day period? They are not so strict, obviously, because of the practical difficulties that we have sometimes to serve these documents on the defendants, especially now these days with the pandemic where people have moved more. They are not, you cannot locate them in their last reported address. There are more difficulties. Also, it depends on the county and the court how strict they are enforcing this 60-day period. To give you an example, the County of Los Angeles is generally more lax enforcing this 60-day period. And why is this? It is just because when you file a summons and complaint and the summons and complaint are accepted, you get the court documents back conformed with a case number, and you get your trial date directly, usually for a year and a half or 2 years after filing. You also get a final status conference hearing 15 days before the trial date. So unless there is an issue during litigation with discovery, because of which you have to file a motion to compel, or you have to appear ex parte for other reason, you are not going to see the judge until a year and a half after filing the summons and complaint. So even though it may not look good, if you've taken 6 months to serve, it is harder to monitor because of the internal procedure LA County has. Other counties such as Orange County or Riverside are way more strict. And why is this? Because after you file the summons or the complaint, they don't give you a trial date directly. They usually calendar case management conference in the case of Riverside, or trial setting conference in the case of Orange County, just to monitor and follow up how the case is going. In the first hearing of this kind, the judge will usually ask, okay, has service been performed? If you haven't after 3 months or 6 months, you may have a problem. So some judges are more strict than others, but usually you want to serve as quickly as possible just to avoid any issues in these hearings, and then also obviously to keep your litigation case moving forward. Obviously, like I was mentioning, you have challenges to serve on the defendant. And why is this? Because you cannot find the defendant in the last address where they have been reported, or you know they are there, you have evidence that they are there in that last reported address, but they are just avoiding service. We usually use process servers to perform service. The law requires only that process servers are over 18 years old and that they are not a party to the case. However, even though many times we know the defendant is at the premises because we see activity, we have identified the vehicle of the defendant, they just avoid service. When our process server or our investigator knocks on the door, they just don't open. Or they just arrive at the premises and they just park the car in the garage, they close the door, so there is no way to serve, even though you know they are there. So recently what we've been doing, since these situations have been increasing, usually because of the pandemic, people have been moving more, we have used the assistance or the services of the Sheriff's Department. And this has been very efficient. Patricia can also attest to this, how it makes a difference when you have a regular person, at least that's the way it looks, knocking on your door versus when you have a sheriff's officer. Usually we've been seeing that they have performed service in the first attempt. People will open the door to a sheriff's officer. Still, there may be issues. Why? Because the person is missing in action. They are not there. We don't know where they are. We have databases that we use to monitor their activity, but there is still no way to find them. What can you do? The last option that we have been using is service by publication. So here it's an option you want to avoid. It depends on the court how strict they are to serve a defendant by publication. Most judges don't like this, and why is this? It's a way to serve just by publication in a newspaper of general circulation in the area where the defendant was last reported. But we don't know if the defendant is there or not. So it can create an undue prejudice to the defendant service by publication. And that's why most judges are going to be strict to sign an order to serve by publication. So what do we have to do to serve by publication? We have to file an affidavit in which we declare under oath that we have done everything possible to perform service. We file a declaration of due diligence with this affidavit, and there we detail all the attempts that have been performed. Where have they been performed? When were they performed? And where? In the biggest detail possible, because you'll have better chances for the judge to approve or to sign the order for publication. So once you have filed the application for publication, including the due diligence report and including the affidavit, the way it works is the clerk's office has a list of newspapers that are of general circulation in the area. You choose a newspaper, the one that you consider more appropriate, and the publication has to be at least once a week for the next 4 weeks in that newspaper. After the 28th day, the summons and complaint are considered served. The newspaper will have to give us another affidavit, and then we will file this affidavit with the court, and the summons and the complaint will be considered served. So that's basically the process with all the challenges and difficulties of service of the summons and complaint on the defendant. And with that, I'll pass it back to Patricia to continue speaking about active litigation and what discovery consists of.
Thank you, Pablo. Can I get the next slide, please? So let's say we've exhausted all options. We've tried to resolve a personal injury case in pre-litigation. We are unable to, we end up filing our lawsuit. You want to make sure you pick the most appropriate venue. And as my personal side note, always try to avoid federal court whenever possible in a personal injury case. Once you've filed and you've completed service on the defendant, we are now ready for game time, right? We're going to serve discovery, we're going to serve deposition notices, and the same is going to be done for our client. We're going to receive written discovery, we're going to receive subpoena for records, deposition notices, and things of that sort. You will receive subpoena records. When you get subpoena records, as the attorney, we want to make sure that there isn't anything privileged or a matter of violating our client's privacy that they would be obtaining in those records unless it's absolutely necessary for the case. You want to make sure to vet the subpoenas, limit the scope of what they can request. So for example, if it's an auto accident, including bodily injury with orthopedic parts, things about their psychiatric past or mental health, unless you're seeking something beyond a standard emotional distress claim, they wouldn't be privileged to. So you want to meet and confer with opposing counsel to limit the scope of what they can get and the time frame that they can get. It's not a free-for-all. They don't get to go in a fishing expedition and dive into the plaintiff's records from the beginning of time, but they are entitled to what is reasonable and relevant to the case. So as a practice tip, you just want to make sure you're looking out for those subpoenas, making sure you're addressing them as quickly as possible, because there are timeframes and deadlines you need to comply with in order to make sure you can bring forth a motion to quash a subpoena if opposing counsel isn't reasonable and doesn't want to work with you. Now, as far as written discovery goes, you will receive form interrogatories, special interrogatories, requests for production, requests for admissions. You want to be very careful with how you respond to anything that may relate to a social security number or things of that nature. As we discussed earlier, the evidence code prevents defense counsel from seeking any information that has to do with the person's immigration status. However, defendants, insurance companies always like to ask for the social security number. They claim that based on Medicare reporting requirements, they are entitled to it. We never produce it. We object to it. It is not relevant to the case. It's not necessary. There's other ways for them to comply with at least that aspect of that reporting requirement for Medicare. So with the written discovery, you want to be careful and mindful to object to anything that would open the door to your client's immigration status. Social Security, is, like I said, is one. You also want to be careful when it comes to loss of earnings, past and future. This is a strategic decision that you need to make when reviewing the case as an attorney, and you also need to have a discussion with your client and get in writing if you will be waiving a past claim for loss of earnings, or they're waiving their loss for future earning capacity as part of their claim. That is something that you want to make sure you always get in writing with them, and you have a sit down with them and explain to them why you feel that it might be best to not bring that portion of the claim forward in the case. Things you want to consider when it comes to past loss of earnings. Are they self-employed? Were they earning cash? Can they prove the income that they're claiming that they've lost? Do they have bank records, tax documents, things of that nature? If you're talking about a smaller auto accident case where they maybe missed 1 or 2 days of work and you are ending up in the litigation arena because there's an impasse in settlement negotiations and it makes sense to proceed, that's maybe something where you might want to have a conversation with the client and get them to waive their past loss of earnings in writing. But if you have a catastrophic injury, a traumatic brain injury, that level of case, you may not be as eager to waive your past loss of earnings or the future earning capacity. So as an attorney, we need to make that decision. If you do have an immigrant client that has a major catastrophic injury and you are going to proceed with the loss of earnings claim, you want to make sure that you decide how you're going to prove that, right? So you can prove that with your client's testimony. If your client was paid in cash and they didn't file taxes, maybe you can depose their employer, and their employer can, under oath, testify as to what this person earned and what their job duties were, etc. And when it comes to future loss of earnings, you want to make sure you hire the right economic expert that can take all this information, review your client's tax returns if they exist. When they interview them, see what their strengths are, where their work history is, what their experience is, to make that claim valuable and to determine what that value is. Be mindful that if you do turn over tax returns, you don't have to turn them over during the exchange of requests for production. It's violation of their privilege. You do not have to provide them during discovery. However, if you do provide them to your expert, be mindful to redact any personal SSN numbers or social security numbers, any information that relates maybe to their spouse or their children, or the income of their spouse, because that's not relevant. But they will get those tax documents when it comes time to exchange your expert's file. So just be mindful and make the assessment early on as to how you're going to proceed with the past and the future if your client is undocumented, and what that's going to entail and how you're going to prove that. I can say that in smaller cases, it's not generally that big of an issue, but when you do have a catastrophic case, amputations, TBIs, things of that nature, that's a bigger determination that needs to be made. For depositions, we represent a high population of Latin American clients, and most of them do not speak English, and they get very nervous when it comes to their depositions. The first thing that we do is reassure them that they're there just to answer questions, nothing about their immigration status, because it's irrelevant. It has nothing to do with whether they got hurt or they didn't get hurt. We will not allow them to answer any questions about their immigration status. I go as far as not even allowing them to answer when they came to the United States. Because who knows, maybe this case ends up going to trial, that deposition transcript becomes a public record, and then that could put the client in some sort of issues in immigration proceeding in the future. We don't know what can happen in the future. So our job is to protect the client as much as we can. The other thing to be aware of in a deposition, your client has the right essentially to an interpreter. They can't answer a question they don't understand. It's very important that even if your client speaks some level of English, if they don't feel comfortable having more than a basic conversation in English, that you notify defense counsel that you do need a translator or a qualified interpreter or certified interpreter, I apologize, in their native language, whatever that may be. Additionally, you want to make sure that when the deposition transcript comes back, your client has an interpreter with them to review that transcript, because all those answers are going to be in English, the questions and the answers. And you need to make sure that when your client is going to sign the deposition transcript under penalty of perjury and not make any changes, that they understand what is being read back to them. Another practice pointer I would say is that when you're in a deposition, if you understand the language that's being interpreted. So for example, I speak Spanish. My mom and my dad are from South America, Peru and Argentina. We have different words for sidewalk, whereas if you go to Central America, they use a different word for sidewalk. So to be mindful also of, if you do understand Spanish, be careful in the depositions and pay attention to the interpretation, the translation that is being made, because sometimes the interpreter is from Central America and might use different words than someone that is from South America for the same item or the same object. So it gives you a little bit extra layer of protection when you are defending your client in those sorts of scenarios or in a deposition. Can I get the next slide, please? Pablo, I'm going to hand this over to you.
So the next step after you have conducted discovery, depositions have been taken. Is the case ready for a mediation? Usually the defense counsel will want to take the medical examination of your client. It makes total sense because usually the medical information that defense counsel has at this point comes from doctors that have not been appointed by them, in the sense of, do we know if they have been neutral with their medical diagnosis? They want to have your client examined by someone of their choice. The law gives them the right to do so. The law only allows the defense counsel one medical examination unless there is a court order establishing that an additional one is necessary. If not, only one medical examination. As I said, this can be a doctor of their choice. There are some limitations. One of them is that the doctor cannot be farther than 75 miles away from the residence of your client. Another one, they have to give you notice at least 30 days before the examination. Once the medical examination starts, it cannot exceed 1 hour. There cannot be any questions regarding accident history, past medical history. They cannot request a social security number. They cannot ask you questions about how the accident happened, about who was at fault, about what kind of negligence was involved. We have to remember that a defense medical examination is not a deposition. The doctor is just there to ask the basic questions that are not invasive. Invasive has been considered, for example, x-rays or diagnostic tests. After the medical examination has concluded, we have a right to get a report, the report from the doctor, and also we are entitled as plaintiffs to have our client go to the examination with an observer. Usually the observer has medical knowledge, and also they have knowledge of the law limitations that are established in the California Code of Civil Procedure. So usually they will object to some of the questions that the doctor asks our clients if the questions are not appropriate or they are not within the scope of what the California Code of Civil Procedure establishes. With that also, like Patricia mentioned, with depositions, our clients are entitled to be understood or to understand when they are asked a question by the doctor. So they have a right to have an interpreter with them because they have to express their feelings, their diagnosis the best way possible to the doctor. That way the information that is included in the final report is accurate because this will be used for litigation. So Patricia, I'll pass it back to you.
Just a quick note on the defense medical exams. When you select an observer to go, if the attorney themselves can't go, we all have very busy schedules and we would love to all be present for our own clients' medical examinations to make sure that the doctor isn't going beyond the scope of what our response or our parameters of what we've notified defense counsel we're going to allow, and we can't make it. You want to have a good relationship with the observers, make sure that they are recording, make sure that the observer is aware and has a copy of what your response was to the defense medical exam so they know what the parameters are and what the client needs to or needs to not do. Additionally, with the interpreters, we get a recording of the from the observer that goes if the attorney can't go themselves. So you want to make sure you listen to that recording, compare it to the defense medical exam report, and make sure that it's kosher. Make sure that the questions that were being interpreted and the answers that were being relayed back all make sense, that there's no issues with the information that was being provided by the client and the questions that were being asked. So it's just another practice pointer to make sure that everything is as good as it can be for your client, given the circumstances. As far as the interpreter and the deposition arena, as well as the medical exam arena, the defense counsel provides the interpreter. Your client has a right to that. So always make sure you notify defense counsel when an interpreter is needed and the language that they're needed in. If you have a client that has a special dialect, they need to know that as well. I know that happens with Armenian interpreters. Sometimes there's a difference as to what country or what area they're from as to the translation and the language that they speak. Next slide, please. So what happens now? You've completed discovery, you still can't reach a settlement. You've had your client undergo a medical exam. Now it's time to think about mediation, right? What are the advantages of mediation? Well, it's confidential. It's kind of like what happens in Vegas stays in Vegas. It's the same exact thing that happens in a mediation. It gives you an opportunity to really take a deep dive into your case and really be honest with yourself as to what the strengths are and the weaknesses may be, and where some landmines or some things that you need to be careful with are. You want to make sure that when you go to mediation, you prepare as well as you would probably for preparing for trial to really understand what the value of that case is. Set your client's expectations as to what may or may not happen. Go prepared with the value range and things of that nature, so your client is aware of what to expect when you attend mediation. Another advantage of mediation is that you get to see what the other side is thinking. What are their arguments? What's going to hold water and what's not? You know, what's a red herring and what's maybe really a problem, because every case has good facts and bad facts. It's the reality of it, and we have to approach them head on. The other advantage is that you get to agree to a mediator, right? It's not one part selecting a mediator for both sides. It's a mutual agreement. So you want to make sure that when you are selecting a mediator, you think about what these issues may be in your case. Do you have a difficult client that, you know, my clients tell me, I want justice. And as Eustace said, it's not an eye for an eye, right? And unfortunately, our system rewards you monetarily for injuries that you've sustained. So you want to make sure that the client understands that, because sometimes we're not the ones that were injured, so we can't necessarily put ourselves in their shoes. It's our job to be objective about it, not subjective, and help them understand why things are moving forward the way they are and why an end result may be possible of whatever nature you think it may be, so that they get on board and that they're prepared for this and it doesn't hit them like a bucket of water when you're at mediation. So for me personally, I think mediation is always a win. If you settle, great, case is done, your client can move on. If you can't settle, at least now you have a better understanding of what the other side is intending to argue and what will hold water and you need to prepare for and what won't. So be mindful when selecting your mediators as well. We all know some are more favorable to the plaintiff side, some more are favorable to the defense side. So pick a neutral that will work for your case. If you also have a client that maybe is not as trusting of you or an interpreter at a mediation, if you don't speak their language, maybe trying to find a mediator that speaks the same language as your client also affords them a level of comfortability to understand the process and be more willing and open-minded to go forward with mediation and possibly resolve their case in that manner. With that said, I'm going to pass it on back to Eustace and Caroline.
Thank you, Patricia. Can I have the next slide, please? I'd like to discuss a little bit more into why mediation is beneficial. As Patricia said, mediation is confidential. So according to California Rule 3.854, the mediator cannot use any information learned during the mediation for personal use or outside the mediation. So in any instance that a mediator learns that the plaintiff is an undocumented immigrant, that information cannot be used. Another advantage of mediation is there is no physical appearance. In today's age, with unfortunately the pandemic, we are having mediations more and more via Zoom. Therefore, the plaintiff's appearance will be virtually, which brings more confidence to a plaintiff that doesn't want to appear physically. Another reason is to have a mediation is the plaintiff's role during mediation is very limited. This is not a deposition. This is an opportunity for a plaintiff to present its case, to show an injury and scar. So it is beneficial to have the plaintiff during the mediation. Lastly, the parties have full control of the mediation, that outcome. So the mediator or the court do not have control of the outcome of the case. The parties do. Differently, during trial, the judge or the jury will have control of that case. If the case is not settled in mediation, negotiations can continue, but if a settlement is not achieved, then the case will go to trial. And I'll open here for Eustace to discuss a little bit more about trial.
So trial is really your last opportunity. Everything else has failed. Your negotiations have failed, and there is an impasse. Oftentimes, I find in this day and age, a lot of times cases don't really get full settlement or aren't able to settle until the other side sees that you're prepared to go to trial. So it's often a situation where you have to get all your ducks in a row, and then all of a sudden they say uncle right before you end up at trial. But that is the situation that we face. So when we're discussing trial, I'm just going to emphasize again, anytime you can stay out of federal court for a personal injury case and you're in state court, it's a much, much better situation. The rules are a little bit more relaxed, and in addition to that, in federal court you have to have a unanimous jury, whereas in state court it's 9 out of 12, so it's a little bit more advantageous for the plaintiff when they're attempting to put on a presentation and ultimately obtain a recovery. The other issue that's important to know is that if you do have someone who is a non-citizen and does not have the ability to stay, federal court, you have federal marshals, federal law applies. It is a very precarious situation if you're undocumented, and one should use all resources to try to stay out of federal court and stay in state court under those circumstances. Trial preparation is a lot of work, and it's usually very intensive work with your clients on many, many different aspects. One, you will usually need their help in trying to track down witnesses. You'll need to prepare them. The preparation for trial is usually much more involved than just deposition, because there you're often wanting to go through all of the medical records with them, other people's testimony. They need to understand how the case is going to be presented, because it'll help them understand the importance of what they do. And preparation is really the key. If you prepare, you're going to do better than if you do not. Your client will do better when they are testifying. They'll be more relaxed, and they'll be able to understand what the pieces of the puzzle are that they have to present to the jury. It's an unknown question right now where things are going to lead as it relates to whether you have to be present at trial or whether some trials will be done by Zoom. A few of those have been done throughout the state during the pandemic, and based on the way things have gone, it would not be at all surprising if there was an effort to try to facilitate the use of more Zoom calls or Zoom presentations as we go forward, including in trial. The trial period is really the first time that the client will have to be, no matter what, in the courtroom for the presentation of evidence. And if you are in state court and your client does not speak English or needs a translator, then you absolutely need to have somebody there. It'll often be important for you to have somebody there while other people are testifying, because one of the very important pieces that a plaintiff and the injured person will provide as testimony is the correction of people who may have misstated things. And so it's really critical to make sure that you don't just have a translator for when they're testifying, but often for the entire trial. That can be a very expensive obligation, but it is something that is often very, very important. The other possibility is if there's a family member who can do the translation, if they speak sufficient English such that they can be doing the translation. But these are all critical things that are very, very important. If you are in California and you do have a situation where the person is not a U.S. citizen, then I find it good practice to be able to speak to the judge, to let the judge know what's going on, because most judges in California will abide by the rules related to maintaining confidentiality and not allowing ICE or any other federal officer come in order to speak with or detain your client. So it's a really important thing, and it's important to also recognize that there are all different types of people out there on the other side, and there are defense attorneys who will try to use this to their advantage and may try to put pressure on you or your client. One thing that I've seen on occasion is there are some defense attorneys who will improperly attempt to remove a case to federal court, even if there is no right to, just to try to scare the other side and see if they can scare them off. So these are things that you need to be attuned to, and you need to pay attention to, because it is not at all uncommon for the other side to try to ask questions, whether it be in court or make statements out loud in order to try to put pressure on your clients. And you need to make sure that you prepared them for that in order to hopefully prevent anything of that nature occurring. Why don't we go to the next slide? We touched on all of this basically. You have a right to privacy. There are different mechanisms. Each judge is going to be a little bit different about what they may or may not be willing to do with regard to protecting your client's right to privacy, as well as any issues around his immigration or her immigration status. Next slide. Generally speaking, in California, the state courts would require someone to, if they're going to come into court, that they would have to have a warrant if they were to arrest somebody. And these are issues that would have to be presented to a judge. So by speaking to a judge and having a good relationship with the court staff and the judge, that is an issue that can be used to hopefully help protect your clients if you're ever in that particular situation. Why don't we go to the next slide? So I think the ultimate thing to remember related to a trial is that it is an incredibly involved process. There is no way we have sufficient time to go through all the aspects of what is required of a trial and what is required of your clients in a trial. But needless to say, it is basically the culmination of all of the work that you had done up to that point in order to ensure through litigation you have sufficient admissible evidence, as I discussed at the very beginning, in order to present your case and to present the testimony necessary for you to prevail. You have to have your admissible evidence on each of the elements of the cause of action that you're going to present in order to present your case. With that, I think we may have a little bit of time left to do some questions, but I know we're running.
Yeah, thanks, Eustace. Yeah, so we don't quite have enough time for concluding remarks from everyone, but I did want to get to the chat questions here. Joanne in chat asks, I guess for Eustace and Caroline, how is Labor Code 244B enforced in practice?
Yeah, so I can take that one. It's in certain ways a bit complicated, right? But end of the day, filing a complaint is how 244 can be enforced. You know, informing another person at the workplace about the rights and seeking, I think the initial response here is to seek information to see if that employer is in compliance with state law and local workplaces law. But end of the day, filing a complaint is how it will be enforced.
Thank you. So I think that's all the time we have for today. Thank you all for listening, and thank you to YouTube if you're watching this for listening as well. And big thanks to our panelists for their time. That was a really great session.
Thank you.
So you'll see in the chats. Yes, you'll see in the chats that there is the program materials link, and then be on the lookout for your MCLE certificate. Thank you, everyone. Have a good weekend.
Thank you. Have a great weekend, everyone.